Welcome all of you to this webinar by ELP, the Economic Law Practices, and the Association of Independent Directors of India. And thank you all for logging in these difficult days. And thank you very much, Mr. Vajpayee, for being with us this evening. And we look forward to your extensive experience in running boards and your previous experience of being head of SEBI and LIC. I think it's a privilege to have you in this webinar. And thank you, Economic Law Practice, especially Mr. Sohail Nathani and Mr. Talwar for being part of this and helping AIDI put all this together. The topic is very, very relevant, as you would all agree that some of the new acts which we have been hearing about since the COVID started, the Epidemic Act, the Disaster Management Act, have not been, as the ELP put it, in the playbook of the directors. So these are new acts which all of us need to get familiar with, because from whatever knowledge I have is from the media news, which is coming around and saying that the kind of liabilities, the criminal liabilities which you have when, not during the COVID, but the post-COVID, right? When the offices start opening, when the factories start working, the kind of expectation which is there from the employers to maintain that kind of hygiene factors of social distancing and whatever you may have, the liability sits on the company, not only the managers, but I was reading somewhere that it would ultimately rest onto the board of directors. And that includes the independent directors. As it is, the independent directors were weighed down by all kinds of criminal liabilities which they had. Now there are two other acts which we need to reckon with. Up till now, I think AIDI, the Association of Independent Directors, has been doing a fairly very good job, in fact, to educate the independent directors on their responsibilities, their obligations, and also the liabilities which they could incur if they do not really participate in the board meetings and exert their status of being independent directors and be able to influence the decisions at the board level. As I was talking to the panelists just before we started this, that some of these webinars have been actually very productive, and we have been able to actually reach out to many of our members, and you will be glad to know that we have about 4,000 odd members who are members of reputed companies, and we have 20,000 other aspiring directors and CXOs who are registered with the Association of Independent Directors of India. ELP is a very well-known law practice, and I think it's I need not talk about Mr. Vajpayee. He's a very well-known personality in this space. He has served as the chairman of LIC and then chairman of SEBI. And he has served on many innumerable committees and various bodies of the government of India. He's been responsible for framing of many regulations. And he's also authored a book, which we very proudly distribute to our members in AIDI, called The Essential Book of Corporate Governance. He's, after post his retirement, I think I've seen one gentleman who's kept himself so busy and disseminating whatever experience and knowledge which he has gained over the years. And that's, I think, what we expect from senior people like Mr. Vajpayee, just not to fade away after retirement, but actually to enlighten all of us on the experience. So, Mr. Vajpayee, I think we'll start with you, right? But I will first introduce Mr. Nathani, who is the managing partner of Economics Laws Practice and is widely recognized and a leading lawyer in India. And all three of you are based out of Bombay, so I think that's the center of all activities. But I think you're taking enough security and playing it safe, because the news coming out of Bombay is not all that exciting these days. All of you are safe and secure. And all those who are logging in from Bombay, I wish them all safe and secure next couple of weeks before everything comes under control. And we hope that we should be able to write this. Mr. Nathani actually he works across corporate, regulatory, labor, securities, trade, and competition practices. He sits on the boards of many listed companies and as an independent director, and has represented SEBI, CCI, and other government of India before various tribunals and courts in India and internationally. He did law at Cambridge University in England, and an LLM from Duke University, USA. So I think he has had extreme uh, experience overseas and within India, and I think he would bring in a different kind of a perspective to this webinar. And Mr. Tawar is the co-founding partner at Economic Law Practices, and he has over 25 years of experience in transactions in hospitality and infrastructure sectors. And prior to ELP, Sujain was a qualified English solicitor with Pinson Masons, UK, and he's also a solicitor registered in England and Wales. So both of our panelists here have extensive education abroad and also has experience of different jurisdictions, which would be interesting to get their perspective today. I think as I open the discussions to the panel, I think key things which we would like to hear from Mr. Vajpayee is the recent reforms, let's put it as reforms in ease of doing business that the Ministry of Corporate Affairs under the leadership of Mr. J.T. Srinivas, who is now retiring on the 31st of May, and a new secretary is taking over, I think Mr. Rajesh Verma from Odisha batch. So, Mr. Vajpayee, what do you think is this? I think these reforms which have been announced by the Ministry of Corporate Affairs and the Companies Act have been there on the anvil for many months, if not a couple of years, right? And that's been something which our association has also been asking for. So why did the government have to wait for this crisis to happen to make these changes, which were already there in the works?
Wonderful question. First and foremost, Mr. Swaroop, thank you very much for a very generous introduction. You are always kind with your words, and in particular to me. For me, it's a great privilege to be part of this webinar. Let me come back to what the question you raised. Okay, first and foremost, let me answer what is the philosophy of bringing about the changes. The discussion at the policy level we always used to have. In fact, when I was working for SEBI, we used to look at from that angle, that what is that we want to achieve. Now, if you want to achieve a particular pattern of behavior, because law does not, by legislating a law, the behavior doesn't change. And therefore, a regulator or a legislator has got to go back to the motivations of a particular behavior. And if we want to change that behavior, then we have to first consider what were the motivations for old behavior and how the new behavior can be changed. Now, some of the provisions in the Companies Act which have been made were criminal kind of liabilities. Now, we are dealing with a civic act. The purpose of behavior of people is to make money. And if you put them to criminal liability, and the criminal jurisprudence being in every country, in particular in India, what it is, then I think we are not going to sort of achieve the objective that we have in our idea while legislating. And therefore, this fundamental point was accepted at the policy level. And at one point in time, I also had an association in those thinking process. And they said, yes, you are absolutely right. If at all we want to change the behavior, if at all we need some cognizance to be taken, it has to be monetary, and it has to be significantly higher monetary, so that his negative act must come to play for it. Now, coming back to Mr. Swaroop, the question that you've raised is why changes at this point in time? India is a democracy. And in a vibrant democracy like India, to get bipartisan support to any issue has its own challenges. It happens in India, it happens in the United States, it happens in UK, it happens in every democracy of the world, that for a very, very small thing which looks to be useful for the society at large, because of the bipartisan support not being available, those changes are deferred. Now, crisis is one opportunity when bipartisan support comes about far easily. And even if it doesn't come, you can take the action and put cart before the horse kind of a situation. And therefore, it is not only a question of these particular reforms relating to Companies Act. But if you go back to 1991, for example, the changes that Narasimha Rao and Manmohan Singh team undertook would not have been possible in case we did not have had the financial crisis when the former finance minister Yashwant Sinha had to physically carry gold to Bank of England to get a line of credit of $300+ million. And I have been a student of economics, and I have gone through the economic history of India. Never ever in the written history of India, sovereign of India has ever defaulted. Now standing that Argentina 9 times, Brazil 5 times, and kind of countries, but India was denied the external credit. So that was a serious crisis, and that helped bipartisan support to come out, and Narasimha Rao, Manmohan Singh team was able to do the reform. This is a time when the crisis is once again looming large, and possibly the current political executive foresees this as an opportunity to be able to take process of bringing about those changes forward which were necessary and which are holding for a bipartisan support. So this is the reason, Mr. Swaroop, why crisis is always used for bringing out deeper reforms.
Thank you. I think, can you throw some light on the reforms which have happened in the sense that
Sure.
really help the board of directors, and especially in the context of the independent directors?
Okay. Well, you want to go there. Let me get first, if you have 2-3 minutes,
Sure.
I can give you a broader view of the reforms.
Right, sure, please.
See, the largest employer of this country is agriculture. And the poorest is the dealing to the people who are engaged in agriculture. And this was mainly because this was not, even though agriculture is known as called to be the industry where everybody is an entrepreneur, is still not prospering because of the shackles that were created. So the reform that has been brought about in Agriculture, Essential Commodities Act, APMC Act, or various other investments that are proposed to be made is likely to bring about significant commercialization of agriculture as an industry. And I am very sanguine that this will benefit. Coming back to the industry, if you look at some of the areas of reforms like defense production, there is a technology, there is an IPR. People don't want to share on a 49 basis. And therefore 100%, 74% on automatic route, hopefully should bring. And this will help India in reducing its import and also getting the kind of manufacturing base here in India. Likewise, number of reforms have been done. Now, so far as the independent directors are concerned, according to me, with all the possible reforms, both in the Companies Act and also otherwise, 2 fundamental principles are there. And that is, independent directors are not full-time directors. And therefore, their responsibility and liabilities has to be de-linked, or they have to be different than the liability of full-time directors, which has come out very clearly. But there is a conscious approach to also ensure that these independent directors apply themselves. They must show that there has been application of mind. And therefore, they must not only attend the meeting, but they must ask for 3-4 things. First and foremost requirement is the availability of adequate and timely data. Without data, if the board comes to a decision, it is not a well thought out decision. Secondly, it's something like that, that you don't do the diagnosis. You straight away go to a physician and say, come on, tell me the medicine. After all, what the doctor do? Doctors, first he puts his hand on your pulse to check your pulse rate, then your blood pressure, then your temperature. And then possibly if he feels there's a need for a specialist diagnosis, he does that. Now, independent directors, therefore, first and foremost, must insist on availability of adequate data and in time, so they have enough time to look at the data and at least assess what exactly is an issue, which we have to tackle. The second is, whereas there's no question of confrontation with the executive management, but you can't completely and entirely depend on the management's view of a problem. And therefore, this application of mind, which is often talked about, that whether independent directors have applied their mind or not, my dear friend, in case there is no data, in case the data comes the last minute, in case we look at the only management kind of an analysis, whatever they bring, and the option, they don't propose an option even. We should look at what kind of option, and then in case you have done so what I'm only saying, the application of mind of independent director would be considered adequate only if he has received the adequate information, data, done the analysis, done the thing, and also comes back what exactly an alternative. So this is what I would suggest. And as I said, they have significantly come away from the practice of kind of taking independent directors alongside the executive directors. The penalties or the dealings have been separated significantly, and it has been done by the SEBI, it has been done by Companies Act, it has been done by even RBI, even in case of default. But what they want is the application of mind. This is one. And second, the application of what talent that you have. And that is only possible. Second point, which is very important for independent directors to do, is to clearly understand what is the role of a board and what is the role of executive management. The role of the board is the enterprise management. The role of the management is the business management. And therefore, if the future health, after all, independent directors, like any other non-executive director also, they have fiduciary responsibility. And if I go back to the definition of fiduciary, means holding the enterprise in trust for the stakeholders. And in case the enterprise does not survive itself, where the question of holding it in trust. And therefore, the fundamental role of a board is to see what is the vision, what is the mission, what are the strategies, how is the resource allocation done, where is the best allocation or not. Now, these are the fundamental strategic inputs which the board must provide to the management. And management then act on the direction of the board. Now, what exactly happens in most of us are seeing that a ragtag agenda is brought about by the management, and then most of the time is spent in only trying to review the quarterly performance. But that's a history. There is very little time, and the independent director's role is to insist on the management of bringing some strategic issues before the board, supply adequate data and information analysis, and then come back with what kind of thought process can be there.
Yeah, you raised some two very relevant points. Let me come to the point of the data, right? Now, we are, as independent directors, we are all entirely dependent on the management to provide us data. Right? There is very little data available about a listed company, and more so for an unlisted company in the public domain. Like if you look at some of the advanced economies like the US and Europe, there's a lot of data which is available in the public domain which an independent director or the board of directors can access. Now, in the reforms, things which are happening, I think administrative reforms are happening, but don't you think there are reforms which are required on the governance side? And more transparency has to be brought in, either by SEBI regulating it, or in the Companies Act or any other relevant act, where there is a lot more transparency between the management and the board of directors and also all other stakeholders.
Well, sir, you are asking one very wonderful question. Let me tell you frankly. First and foremost, which many people don't know, that all the regulators, including Ministry of Companies Affairs, insist now XBRL format. Now, in case any filing is done in XBRL format, that anybody can extract data and then do whatever he wants to do with that analysis. Now, first and foremost, deficit in the process of performing the role, Swarup Saab, is that we don't ask management to pull out the data from various regulatory sources and do the analysis. And they will tell, no, this data is not available, this is not doable. XBRL format is compulsory both by IRDA, SEBI, RBI, and Ministry of Company Affairs. So this is one part of it. See, independent directors are not full-time. And we have to be very clear, they cannot go and searching for the data and do the analysis themselves. I'm very clear about it, but they must insist on that. But real issue, Swarup Saab, let me tell you frankly, I have been on the boards, you rightly mentioned that point. I mean, I must have spent almost 4 decades, except with a brief period. And that also I was in the board of SEBI in the boards of the companies. Many times management have skepticism about the non-executive directors. And that skepticism is of two kinds. First and foremost, whether they will keep the data confidential. The second skepticism is whether they will make use of it. What is the point? Now, and this is happening mainly because there is very little interaction between the management and the non-executive director other than the board meeting. It is only in some kind of, I'm not necessarily suggesting that every time a board meeting are priorly, there should have lots of dinners, lunches and kind of thing. But once in a while, there should be a possibility of meeting the management other than the board meeting and then trying to build a trust between both of them. So this is where is the issue, Swarup Saab, in the current day, according to me, where the democratization of information and knowledge has been done. Availability of data is not an issue. It's the role which is not being played by the management, and that is not being played by the management because board is not insisting upon playing that role.
Right. Oh, I appreciate that. Yes. I think coming to the current situation, right? Even if someone doesn't, office is open where the companies where we are on the board, and this famous thing of do gas ki duri, if it's not maintained, then what's our liability? Mr. Nathani, you will have to throw some light on it. If do gas ki duri is not maintained, then what happens to us?
So thank you, Mr. Swarup. Bajpai Saab, it's really a pleasure to come into this panel with you. We have put up a few quick slides and we'll answer the question, Mr. Swarup, quickly in terms of the slides and the duties. So we'll move on to the next slide, Megha, please. So this is what the global view is on what a board needs to be doing. And Vajpai Saab put it in perspective as well when he spoke about the role that an independent director or directors indeed play in the operations of the company. And of course, the new trend is that you don't have a responsibility only to the shareholders, or you don't have a responsibility only to maximize profits. You have a responsibility towards all the stakeholders. So that creates a lot of moving parts when you fulfill your role as a independent director on a board. Can we move to the next slide? So 149.12 talks about the independent directors. Of course, Vajpai Saab spoke about how the liability of the independent directors needs to be different from the liability of those who are operating the company. This is quite honestly not the first time that the government of India has tried to do something. On 29th July 2011, they came out with a circular as to who should be held responsible and prosecuted. But this circular is different because this circular mentions independent directors by name, and it says if you're in doubt, please reach out to the Ministry of Corporate Affairs before filing any prosecution. And this has become very, very important for all of us because there's so many laws, and we'll just touch upon those briefly, under which the entire management and the board of the company is exposed. Can we move on to the next slide, please? So these are the laws that we are dealing with in today's time. There's an Epidemic Diseases Act of 1897. There is a Disaster Management Act of 2005, and Epidemic Diseases Act, like all those lovely laws in India, go back almost a century, but they're still in force. That had to do with the coming of ships into the Indian borders. Still applies because it applies to aircrafts and ships and everything else. It's really a 4-section act. The Disaster Management Act is a more recent act, and although it was designed not for this purpose, this act has been used to issue several notifications, and I will deal with those in the next slide. So if you see under section 10(2)L of the Disaster Management Act, the National Executive Committee issued a statement saying that all the employees need to be paid on the due date at their workplace without any deduction for the entire period that the establishments are under closure during the lockdown. And this created a lot of problem because several companies were not operating. B, how could you have people coming to the workplace and collect their monies? And it created a huge flutter amongst management and boards of directors alike. And we, I can tell you without naming names, as a firm actually took a position on this, that companies need to be paid the salaries. But one client of ours told us, if we don't have the money, we are not going to be able to pay these salaries. Let them prosecute us and let us see what happens. And of course, as you know, all these are under different levels and degrees of challenge in the Supreme Court. And today the Supreme Court has said there should be no coercive action, and that they will hear this matter within this week. There are issues as to whether this power extended to giving them the power to make you to pay people under this directive. Similarly, the state of Maharashtra also, under section 24 of the same act, usurped some powers and said that you will continue to pay the staff. Now, today you're sitting on the board of a company. You are responsible for all the stakeholders. You know that there are no operations going on. You are now mandated by an authority to make you pay a certain salary, knowing fully well that the company may actually be jeopardized by this situation. And the next slide, please. This brings us to what was raised by Mr. Swaroop, which is, safety at work. You have to buy insurance, reopening protocol, and all these issues are very, very, very real time. On April 18th, a biscuit manufacturer in Maharashtra opened, and he was raided by the authorities, and they found that there was no adequate protection. They filed FIR under two sections. One was under the Disaster Management Act, and one was under section 188 of the Criminal Procedure Code, saying that you have not followed the orders of a public servant. I am not sure whether this was filed against the entire board or only the operating directors, but that is an exposure. 2 days later or 3 days later, the government of India came out with the clarification saying there will be no liability. Now, Mr. Vajpayee also mentioned in his conversation that where there are so many problems with the criminal justice system, you may eventually be acquitted. In fact, in 99% of cases, you get acquitted. But the process of acquittal is so much of a problem that you may have to apply for anticipatory bail. The risk of applying for anticipatory bail is that if it gets rejected, and even though you were not going to be arrested, then the authorities become emboldened to arrest you. So these are issues that all independent directors stand exposed to. I'll just touch upon one last slide on the criminal liability under the Disaster Management Act. And once again here, there is no difference between directors and independent directors. And there is a great deal of overlap. And if you are caught under any of these sections, of course, then the due process of the law takes over. We have a similar position under 66(2) of the IBC, which does not make a distinction between independent directors and other directors. And there could be exposure in IBC proceedings as well. So I'm sorry, Mr. Swaroop, I just took the opportunity to run through some of these slides to put it in perspective.
Very interesting.
But I hope that answers your question and then some.
Yeah, the question which would be there in the minds of the people who are listening to us would be that is it wise for the boards to tell the management that they should go back to normal operations in these circumstances when there are so many safeguards to be taken, and you know that how the labor force in this country and as how the processes are designed. If you're saying that you need to maintain safe social distancing and do all kinds of things, there are certain processes in factories which actually do not permit these kind of standards and these kind of things. So if there are criminal liabilities which the board could incur, don't you think that many boards will take a very conservative point of view and say, okay, let the COVID be over and let's not face these kind of prosecutions? And
Mr. Swarup, that's a very, very real question and a real issue. We saw the LG polymer plant and the unfortunate accident in Visakhapatnam, and it creates all kinds of liability issues. I think you would be negligent as a director if you directed the company to open. You need to allow enough time for sufficient standard operating procedures to be put into place. In fact, the liability is also now directly on the management and the CEO for certain things. So, you know, we are trying to open our offices in various locations, and the circulars actually say that the CEO shall make sure that there is adequate social distancing, disinfectant, whatever, and that creates a huge problem in terms of the liability and exposure of directors. So, short point, I don't think any director should be directing or insisting that the company open, even at the risk of, you know, the viability of the company being further jeopardized, because many companies have been shut for over a month and it can be a little longer. And there could be a lot of financial exposure over there. So I think, no, has to be a lot more prudence, lot more care and caution, and lot more calling for accountability on the management, saying, please satisfy us that you have complied with this.
so for the independent directors, do you think it will be necessary or it is prudent for the independent directors to ask the management to have a standard operating procedure on which the board signs? And would that be enough to waive off any kind of criminal prosecution of a director if there is a standard operating procedure which has been put in place, right, which the board has approved? So would that be enough for?
So, Mr. Swarup,
Because it will not be feasible, right? Many of these companies have several plants spread all over the country, right? To be ensuring that these procedures are followed. So the liabilities could be sitting anywhere.
Mr. Swarup, you're right. And one approach to this is to make the management present to the board what they will be following as standard operating procedure as part of the opening process. This needs to be debated and deliberated at the board, and the risks need to be identified. And a very important point here is that as an independent director, if you have a different view, you need to be speaking your mind at the meeting, and that is not sufficient. Nowadays, of course, meetings are recorded, so there will be a responsibility. There will be a record of what you are saying or doing, but make sure it is adequately minuted also in the books that your point of view was made clear. Of course, you're there to help the company, but you have to do it with a great deal of care and prudence, especially in these times.
So, Mr. Vajpayee, I'll just ask you one question before we go to Mr. Talwar. Is that what Mr. Nathani is saying, that one needs to exercise a lot of prudence and at the board level to be able to get out of this lockdown and ask other companies where we sit on boards to have a standard operating procedure to be able to reduce the liabilities which we may have. Do you think that it is practical? Because I sit on many boards and none of my companies have got back to us, even telling us that they are reopening and what are the standing operating procedures they are following. We only get to hear from some of the employees that we are going to the office tomorrow. So what are the liabilities which we could?
Okay.
So why are
okay.
not?
It might be useful to. it might be useful to give you a practical example. I chair the board of a consumer company, which is a part of essential goods. And therefore, and also, since as Mr. Nathani was also hinting at, it is an existential crisis for the companies. If they don't open, they are in for insolvency. If they open, they are in for being charged under various provisions of the various laws that have been put in. Now, what we have done, and Mr. Nathani, I, as the non-executive chairman of the board, took a slightly different approach. And that approach was, these standing operating procedure will change with the changes that government is making on a day-to-day basis. And therefore, we haven't insisted on bringing the standard operating procedure before the board. We insisted on CEO and his team of safety people and the risk managers to come and give a presentation to us that they are complying with all these provisions. And whatever points we had on that, we made sure that this is recorded. That's number one. Number two, what we are doing it, because these meetings are taking place very frequently now. Every fortnight, we have to review what is happening to the company. In every meeting, the first and foremost question or the agenda that I insist is, please tell me whether you have followed all the laws, safety rules, and all that or not. And they give us a confirmation, which we record the confirmation that we have followed all the laws, all the rules, all the regulations. Because even board should be, according to me, board should be taking a responsibility on SOP. If the boards take the responsibility, then suppose, after all, we are not full-time directors. I may not have an access to, I don't have even the time to go through every provision of the law, take the help of ELP everywhere to tell me whether I have followed all the protocols or not. It's the management who has to take the help of they are full-time. So all I will do is, A, to ask whether they have a standard operating procedure. 2, who has verified that it is adequate. C, whether they have taken expert opinion. D, whether it is being followed. Give me a confirmation periodically. This is my approach, Swarup Saab, which is what we have followed. Because in case if any director, whether executive or non-executive or independent or non-executive, takes the responsibility upon itself either to define the standard operating procedure, board doesn't meet every day. These may change every day.
Mr. Bajpai, I was not expecting the board to draw up the SOP. The management has to present the SOP, and then the board needs to apply its mind. Now, if you rely totally on an external consultant, perfectly all right. A reputed external consultant who's given you clearances, that's one approach. 2, there could be a situation where you want certain questions to be answered, and effectively, my approach is the same as yours, because every time you reconvene, you ask for a compliance.
Compliance, exactly. Because what I'm telling you is that board cannot sign off the SOP. The moment you sign off, you take responsibility of everything that is written in the. What we are doing is we appraise, give our issues, get them recorded, which means I have applied my mind. And I've taken the opinion of an expert. This, I don't know. Maybe adequate. So, I would be happy to know your view on that, because you are the person who defends us.
My concern comes from Section 58 of the Disaster Management Act. It says that provided nothing in this subsection shall render any person liable to any punishment provided in this act, if he proves that the offense was committed without his knowledge, or that he exercised due diligence to prevent the commission of such an offense.
Yeah. And that's so I'm excited to due diligence of taking an expert opinion, giving my views, if any, Hannah.
Absolutely. So, sir, our approach is the same.
Okay. I misunderstood you. I must
No. I'm not.
Okay, so can we come back to another question?
Yeah, I think.
No. Yeah, but this debate is necessary, Mr. Nathani, because it helps me to clarify. I am right now, see, I can tell you the name also of the company. It's a Future Consumer Limited. It's basically a consumer goods company which supplies, daily things to the market. No.
Yes.
Now we insist on CEO to confirm that people's safety is first, and all attendant thing later on. In fact, I have changed the whole priority of the thing. Let me tell you frankly, in the board now, the priority is the people first, then is the supply chain, then is the customer, and then is the cash flow. Normally, it used to be the reverse process. We used to ask the cash flow first and then all those things. I said nothing doing. Let's have different priorities now. First and foremost are the people, whether my own internal people or the people whom I'm dealing with outside. The two is my supply chain. Suppose, for example, in case of future consumer, we use a supply chain. Whether we are taking adequate care of the supply chain, their concerns and concerns with them. And the third is then whether customers are being given what exactly they want and the way they want. And fourth, finally, whether we are making some money also.
One final question to Mr. Nathani, and then we can go to Mr. Talwar. Is if offense does happen, right, and an FIR is filed and the prosecution goes ahead to pursue that FIR, what are the consequences for the independent directors? What kind of penal action would he be subjected to?
Sir, like I said, in that biscuit manufacturing case, and although I don't know if they went after the independent directors, they filed under two sections. One was under the Disaster Management Act, and one was under the Criminal Procedure Code for disobeying the orders issued by a public servant. So both of those came into play. Of course, there could be various degrees of negligence which have a criminal aspect of it. So as much as I hate to say it as a lawyer, I need to say it here that it would depend on the facts and circumstances of the case. And then, the question is, depending on how the inquiry goes, can you move for an early quashing because you were not in charge of the operations of the company? That is, of course, fact specific.
One final one, which for people who do not have knowledge of the disaster acts and all that, just a question, right? In like the cab aggregators, right? In the taxi, you are not allowed to have more than 2 passengers, right? If a taxi is fined for having 3 passengers, then who's liable? Are the promoters and the directors of Ola and Uber in India liable for that? Or
So, it would again depend on the operating procedures or the standard operating procedures that they have put to their workforce. If it is unequivocal that you will terminate the ride there, or you will not initiate the ride if there are more than 2 people in the taxi, and the local guy has disobeyed this, I believe the liability should not be on the directors, but you will have to keep on reinforcing the message. So you have to create, if you will, this culture of compliance with these laws. And as Mr. Vajpayee so correctly pointed out, these change every week. Today it's 2 people, tomorrow they may say 3 people, it may say 5 people from the same household. So all these things are moving parts, and you need to create this culture of compliance within your workforce.
yeah, coming from there to Mr. Talwar, when I asked the question that whose liabilities would be, so what are the mitigating factors one should consider that the risk is minimized, if not eliminated?
Many factors, sir. As my predecessors have said, you as a independent director or as a director, I think it makes very little difference. Your duties are now in a way enumerated under the statute. In the past, you used to rely on general company law to say that you have a fiduciary duty. But as I think what Mr. Vajpayee and Suhail rightly pointed out, we are one of the few countries, at least in the emerging world, that has actually written out each and every director's duties, because not every director is a lawyer necessarily. Number 2, they have and this is where I think the biggest problem lies for independent directors and directors generally. They are now confused because they were all brought up in the ordinary company law that as a director, you are liable and you have to act in the best interest of the companies, which was regarded 99.9% as the shareholders of the company. And your focus was blinkered to act in the best interest of the company. And therefore, as Mr. Vajpayee said, though he has changed it, and I think rightly so, the focus was on profits, revenue, growth of the company. Everyone else was not a statutory duty. It came as some sort of implication. But what we did in the new act is we specifically put out that a director under section 166 is now not only accountable to the company, accountable and his statutory duty, and I'll come to the relevance of this. He has a statutory duty to act for the company, the employees, the shareholders, the community, and for the protection of the environment. Now put yourself in the shoes of a director who says that, to save X amount of profits, I need to make some people redundant. Whose interest is he acting in? He will be put in this very, very difficult situation because of 166. Either he relies on a best judgment rule, as some people in the US are saying he will be relying on, or does this logically not open up the gates to say that today, if he doesn't act in the interest of the employees, and if he makes all of those statements, as you're hearing some companies hear them to say, that we are actually not going to lay off employees, we are not going to cut their salaries. And people are saying, yes, this is the great thing to do, very laudable. But wouldn't you say that if you looked at 166, they are partly acting as what they ought to be doing as per the law, as opposed to getting bonus points for not cutting off or laying off salaries? So we have to be careful that, in fact, if we do not do that, you may be, as a director, liable to a claim from employees, etc., for not taking care of their interests. The second point, I think, because one of the issues that we as directors want to use this session for is to come out with something that where there is a lacuna, where there is a doubt, if we can get a clearance from the government, then it will guide us on how we should act as a board member. Partly we come with our own skill sets and our own conscience, but we have to also look at the law. The law does not distinguish between all of these 5 items, company, community to environment, as to what is the hierarchy. Are you saying that if I have 2 plants and I could save all jobs by selling off 1 plant, I should do it? So I sacrifice future revenues for employees. If I have to say, start a business where now, for example, because of COVID, you're going more online and you may not use the traditional marketing methods, should you make those people redundant and now spend more of money on marketing at the expense of the other? This expense of the other, one or the other, is going to cause a problem. In times of COVID, when people have more time and I dare say less money, you will always be looking, whether as an investment manager or a fund or someone in corporate governance, to say, let me see how I can try and get back that money that I'm losing. And so I think there will be a time very soon, particularly in the United States where this law is there, and in some other countries, where people will say, you have chosen one over the other, there was no hierarchy, and therefore I dare say some litigation along this line can happen. So what I would love to get from the government, honestly, is some sort of clarification on what they believe is the hierarchy. Let me tell you, in England, there is a hierarchy. They say shareholders comes first, but we also have to take into account of this. There is no hierarchy here. Everyone is standing in the same equitable manner. The second issue, I think, when we talk about liability, one of the swords, if I may use my name, the talwar on the head of most directors is, all right, I'm only coming 4 or 5 times a year to this company. As Mr. Vajpayee says, I'm only as good as the data you give me and the time that you give me to absorb it, to put down my thoughts. But if you don't give me that, and suddenly I find myself with a claim from some police officer who has come to my house saying that somewhere in Kerala, the Provident Fund was not deducted or paid on time, or that I have, unknowingly created a situation where a personal liability has visited me, nobody is going to become a director. Nobody is going to even take on that role. And thankfully for 149.12 and other circulars, there has been some appeasement to this situation. But otherwise, the general law is that if you, as Suhail has rightly said, at least apply your mind. Do not look the other way. For matters which is not your expertise, and there may be many matters that come up to your board level, which you do not have the expertise. You are not supposed to be the master of all after all. You are brought in because of your expertise. So there is a technical issue. There is an IP issue that someone is talking about. You may not know anything about it, but the law permits you either to inquire by asking reasonable questions, but the right thing would be to do is go out and get an expert. Both SEBI and the law allows you to do that at the company's expense, to get someone to guide you on whether it's the right thing or not to do. So please do your diligence. And as Suhail rightly said, ultimately what happens in the case of a liability, it is not decided today. It is decided 4 or 5 years down the line. It is always historical. Historical means they will look at the most contemporaneous records. And which is the most contemporaneous records in the case of a director? It is always the board meeting minutes. So for God's sake, all that things that where we nod at each other's head, pat and say, "Yeah, theek hai, ho gaya," don't worry. You look back 2 years and said, "I told you not to do that. I told you to take advice." Wo likho. Please get it written in the minutes. Don't feel bad that the chairman of the company or the promoter is saying, "Arey, why are you making me write this?" Nothing wrong in it. And where you just can't apply your mind in the sense you cannot contribute, my advice to many clients has been abstain from that. Abstain from that resolution. Don't say yes, no, because you are not supposed to honestly know everything about every aspect of every company. So I'm on the boards of a hospitality company, an infrastructure company, a manufacturing company. I may know some things about it, but there are many aspects where I say, please bring in the expert and let me understand. So when you're talking about liability, those are, I think, some of the practical means that you need to take. Sir, I think you are on mute.
No, I'm fine. You can hear me, no?
I think
you must be asking. I think Mr. Swaroop may be on the mute.
I think he was asking a question.
Yeah, okay.
Yes,
yeah.
I have a question here. That's would the DNO policies which most of the companies take for board members, does it cover these two acts?
Yes, sir. I think it's one.
Yeah.
I've got it on the screen. Now, one thing, sir, we know that God forbid if a company went insolvent, your indemnity is useless. So all of us are relying very heavily on our DNO policy. The reality is that some companies, insurance companies, are selling this DNO policy as a commodity. What tends to happen is you believe what you read as the title. DNO policy, directors and officers, liability is covered. You generally think that that is my safety. But we had an occasion for some clients to examine it. Sir, events have taken place in the recent past, where directors, however innocent they were, their accounts get frozen. They do not have enough money even sometimes to pay the school fees of the children or to even travel. That time you need somebody like a Iqbal Chagla or a Janak Dwarkadas to come and help you with the NCLT to get some sort of a retrieve or a release. Depending on how it goes, you may actually find yourself funding that litigation right up to the Supreme Court. Unless your DNO policy starts funding you very early on, you will find that you are, first of all, in a terrible jeopardy because you have been called in for something you haven't actually done knowingly, but because the public pressure and the pressure is there, you are all, clubbed together with the same thief, if I may call it. And therefore, there is a pressure on the NCLT also not to give you an easy release or a reprieve. So your DNO policy, honestly, is your lifeline. At that point of time, if you do not have all the things that you need, and I can list out a few on the slides. If you do not have this, please go talk to a good insurance broker, and not necessarily only the company who has bought that policy. Talk to a good broker who should guide you on what you need. What is happening today, by definition, we are saying is unprecedented. But has it therefore been covered under your policy? We saw in the hospitality sector, sir, there is that sector has suffered so much. No revenues, but you are compelled to pay employees and wages, etc. Not a day of, you're completely locked down. What happens in that situation? You rush to your business interruption policy. Yes, great title. So you feel all right, at least for 3 months, my business losses will be covered. We went to the insurer. He says, oh, please read the fine print. Your business interruption policy can only kick in if your hotel was damaged on account of something and you lost your business. Now, COVID has actually, we know, caused the world's greatest damage, but the insurers are saying that is not the damage we had written in the contract. There should have been a fire or a flood or anything like that. So this is one area where I really advise clients as well as directors that there will be specialist insurance brokers, specialist people who can advise you on what is there and what is missing. And the question I ask my insurance broker always is, don't tell me what I'm covered for, tell me what I'm not covered for, because that is what I want to try and cover. So, Megha has very kindly put up all these things on the slides. We are facing the difficulties today is that we are all working from home. We are having board meetings from home. We have probably broken every protocol that is there in our board minutes, every damage control situation, every internal control. Even I dare say the SEBI insider trading rules where people around the house can see confidential papers. We are running at a real risk. And if our policy doesn't cover us, God forbid, if something was to happen, then what will happen?
I have a very interesting question.
I can only add one thing, and which is what Mr. Talwar, your slide did not carry. Therefore, if you kindly don't misunderstand me. See, in one company, all these conditions were taken care of, but the sum assured cover was only 5 crores. I said, which country or which one you are living? 5 crore is not even a peanut, if you have to hire Iqbal Chabra kind of people, that's the point. See, many times we make sure that all the conditions are covered. I asked the company, how much is the cover? They said 5 crores. I said, for whom? For you? Kind of thing. So that is also very important, actually.
Yes, absolutely. Okay. And what you need to be careful is that, is it per director or for all directors? And another very important point, sir, as we all know that after 5 years, we retired from one company and moved to another, generally speaking. Some policies actually don't cover you once you have retired.
Yes.
You have to make sure that those sort of exclusions are removed and you are covered for that. So I don't know, I put up a few points, but my takeaway honestly from this is, please run your DNO policies. If you're on the board of 5-6 companies, run it through some good insurance brokers and find out what is missing.
I had one interesting question from one of my employees here that you're asking us to work from home, but my appointment letter says that I have to attend office. So do you need to amend my appointment letter to allow me to work from office?
Tell him he's in breach of his appointment letter.
So typically what happens is, where you have employees as opposed to workmen, employees you govern by the contract that you have written with them. And if your letter says that work from office from 9 to 6 or whatever, and there's no option to work from home or modify the directions, he's right in asking for a formal modification, but certainly you will continue to pay him and continue to be liable to pay him because you've made him work from home.
Yeah, I mean, these are practical problems which many people's mind will be coming with, that am I covered legally or not covered when I'm working from home? My actions from home, are they taken as with the same force as it would have been taken out of office, which is my actually assigned workplace, right? So most of the decisions being taken are not from the assigned workplace, but outside those. So would these overarching guidelines from the MHA or any other authority would override all those provisions?
The short answer is yes, sir, it would, because it would be an act of law, and you can't act contrary to the law. You can't ask for a contract to be performed contrary to law. So that today the notifications have the force of law.
I think we have a panelist who has just joined us or is joining us from Germany, right? Christian, I think he's from, is he there?
Yes, hi there. Sorry.
Oh, hi, Christian. Hi, how are you?
I'm
Mr.
fine.
Swaroop, if I may introduce Christian very briefly.
Yes, I think-
Christian is a lawyer by training, works for a English law firm, is based out of Munich in Germany, and the firm is called Pinson Masons. Christian has spent a lot of time in India. I think he spent about 6-7 years in India, living in Mumbai, working with German companies in India, and is now still active on the India front as part of the India practice group at the firm. And he will bring us an international perspective to what is happening in terms of corporate governance in other parts of the world, especially, of course, Europe.
Thanks, Christian, for joining us. I think
Well, thank you very much.
Germany has been one of the countries in Europe which has actually bounced back faster than anyone else.
Yeah.
Relaxing laws and lockdowns. So
it is improving indeed. I mean, we've had quite a long period. I live in Munich, Bavaria, and we have a federal system as you do. And some of the states are a bit quicker in opening up, others are slower. Now, Bavaria always likes to be particularly safe and strong. So we've been the first one to have the lockdown, and we're the last ones to come out of it. So it's been a bit more than 2 months now. But yes, things are improving, and I very much hope that the situation in India is improving as well, and that soon things are back to probably the new normal, at least, if not the normal. I've been following the discussion, and I mean, very interesting for me. I've as to have said, I in my early days, really, when I was young and adventurous, I spent a good number of years in India, and I also acted on a few boards of, in particular, Indo-German joint ventures or German wholly owned subsidiaries. And so it's really interesting for me to have a bit of a refresher and see how things developed over these many years by now. Probably more interesting for you, there may be one thing from a German perspective. I mean, the general framework, as you would expect, it's not all that different here. Obviously, directors, independent directors do have their various duties in relation to health and safety, in particular directors, in relation to general correct representations as to the financial situation of the company, etc. And of course, then the probably main topic really, insolvency related obligations. Now, basically, a director must never be too slow in filing for insolvency. And that is one thing that our government was very quick in addressing now in the present crisis. Actually, as early as 19th of March, the government decided that companies and directors should be released from the obligation to file for insolvency up to 30th of September this year. So basically, the government realized that with the magnitude of the development and the uncertainties associated with it, in particular supply chains, etc., it will really be an unfair burden for the directors to have to always know exactly where things are going and then make the call whether or not to file for insolvency. So until 30th of September this year, German companies are effectively exempt from having to file for insolvency. Now, why that is in a way a good thing, in particular, of course, for the directors concerned, it does, of course, also have a downside with the other businesses that are engaging with these companies that are now probably a bit late in filing for insolvency. So from an Indian business perspective, there could, in theory, be a situation where you are dealing with a German business, you know of the otherwise fairly strict German insolvency laws, and you feel protected. Now, you could have a situation where that company is now effectively delaying filing for insolvency. So in the next 2-3 months, it may actually be technically insolvent, but you would not become aware of it. Now, I don't want to, raise any concerns or create any panic, but I thought in the context of this very interesting webinar, it might be something that I could share from a German perspective.
Yeah, I think I'll just ask a question coming out of this to Sohail. Right? What could be the liabilities of directors globally? Because a lot of our companies export services, right? Have their own people working overseas. Could there be any liabilities arising in Germany, for example, for an Indian firm who has some contracts or is working in Germany?
Well,
So,
no, yeah, sorry.
Go ahead, Christian. Go ahead.
Yeah, I mean, you could, of course, have all the, call it the usual scenarios where I mean, particularly, of course, looking at supply chain related issues. I'm sure force majeure, all of that, you would have heard it probably more often than you wish for in the last couple of months. In terms of the context addressed now, I believe in the seminar, if an Indian national, even if residing in India, happens to be on the board of a German company, then of course there would not, per se be any difference in the treatment. So yes, he could be liable. He would have to fulfill his obligations. And then again, I think Sujan, you mentioned it. D&O insurance would be a very important thing to have.
So, Mr. Swarup, from an Indian director's perspective, I think, whatever defenses that are available to him in India for non-performance or inadequate performance of a contract could be transposed to the foreign jurisdiction as well. And we saw that when there were orders placed for PPE equipment and the government of India came on out with the ban for exports, and many companies could not perform. We actually had inquiries to bring legal action against such companies. And we believe that the government of India notification is an absolute defense in such circumstances, whether the performance was to be in India or it was to be outside of India.
Thank you, Christian, for being with us.
Thank you.
Yeah. And I think we have time for just one or two more questions and then we wind up. One of the questions which I have received here is that if there's a conflict on the board, then how do you resolve it in terms of especially the COVID situation and the 2 acts? Then Mr. Bajpayee, would you like to take that?
No, but one has to be very clear what kind of conflict is that. See, first and foremost, one has to realize conflict with what. So it has to be specific. It can't be general. Conflict has to be resolved on what is the larger purpose that can be served by taking a decision. And therefore, if the larger purpose is served by taking a decision, we better take a decision. And if the larger purpose is served by taking B decision, we take a B decision. I don't think I can give you a general. That's the way normal common approach evolves. For example, I can give you an example. When I was working for LIC, we had to take a decision which was going to be against the interest of a few employees. But we had to take the decision because it served the interest of larger sections of the employees. And we went ahead. That was the conflict. Therefore, it will depend on conflict itself.
Yeah, I think that is true. I think here the question is much bigger than the immediate stakeholders of an enterprise. Here the stakeholders, when you are in a situation like COVID, the stakeholders become the larger citizens of the country, because you are actually creating a situation where they could be in danger.
Yeah.
So what is the ESG kind of policies which you would advise the Sujain, Sohail, and Christian, Mr. Vajpayee, that you are just not addressing the stakeholders, which are your shareholders, your vendors, your employees, but you are actually a part of society. You are actually
before the lawyers come in to reply, they are the right people to reply. But let me tell you my view. My view is society itself is a stakeholder, which is defined in the Indian Companies Act now. And if the larger end of the society benefit by doing this action, there is no conflict. Whether the interest of a few other is alienated. That's the point I would look at.
Right, I understand. So what are the liabilities, Sohail and Sujain, if you can come in?
So let's just take
an issue about a business.
Let's just take what Mr. Vajpayee and Sujain had spoken earlier. Yes, there are many stakeholders. As Mr. Vajpayee said, the state or the country is also a stakeholder. But you could be in a situation as a director where your company will be bankrupt sooner rather than later by acting solely in the interest of one or more of your stakeholders. Your only defense at such a point is that it is mandated by law. But at some point, when you are seeing these opening up of areas, I think it is also your duty to make sure that your company gets back into action as quickly as possible so that you can start serving the other stakeholders as well. So yes, in the short term, national safety, security, but the moment you get a reasonable chance to open, you have to be at the forefront opening with due care and caution, because there is no priority in the stakeholders and that keeps moving.
So can there be liabilities coming from the general citizens or
So typically not the general citizens, but suppose I am sitting on the board of a company and the company is allowed to operate with certain protections and procedures in place. And as a board, I say, no, let's be played very cautious and let us not open at all until the vaccine is developed and delivered. I think you'll be negligent and you can be held accountable by your shareholders for this. And don't forget, India has not yet started testing class action suits. This would be a terrible time to start testing it. But, these are negligent acts by the board, even though they may be in the best interests of the country and the workers at some level.
But can the community around a factory say that you have been negligent by starting your factory?
Honestly, if you do it in compliance with the law, I believe their grounds of saying that are limited. Yes, that the villagers don't want people from outside coming, but if you come in with PPEs, come in with due care and caution like the government is mandated, I think you won't have that problem. And you really need to start operations sooner rather than later. So you can't wait until the atmosphere is back to normal.
It's been very interesting. So I think we still have time for one last comment from each one of you. So Mr. Vajpayee.
I think I have already taken more than the time that I should have taken. But my fundamental approach for a company is that while we have to deal with this situation, we have also to ensure that the company lives on. And therefore, we have to find a balance somewhere with the interest of the stakeholders of the company per se, and in general environment of the country.
Yes, to you, Sohail.
So my short point is that there are duties of directors, there are duties of independent directors. I believe today you have an enhanced duty. That duty is far more broad and widespread. And as independent directors, we have to help management and all the stakeholders recover from this COVID. There will be huge challenges, and Mr. Vajpayee said it, that these regulations change every day. Post this, You could have issues on collaborating with your competitors, which could lead to a competition exposure. You could have disclosures which are inadequate, and you're signing off as a director that you are doing all the compliance with law in your board report. All those kind of conduct that is post-COVID recovery also will be under scrutiny, and as independent directors, everybody has to be very vigilant on this.
So,
Yeah, I think everyone has said the right thing. I would only add that public memory is very short, and I can lay a wager that in 6 months' time, people would have start behaving as if they were behaving in January, which means 2-3 things happen. Those who have made losses on the stock market will try and find a way to recover it from those companies on some ground or the other. And there are a plethora of regulations, as Mr. Bajpai and all of us very well know, that we have to keep the market updated. When we open, when we don't open, we have to go back to our guidance numbers to see whether we have done it or no. There is a heavy risk. So while this pressure is there from the entire world and in India that, oh, we are helpless, please don't forget that people, the regulators and stock markets will come back at you that you did not comply with X, Y, or Z, you did not inform it. And so my advice is we should continue to play our role as independent directors, which is that we must identify the risks and be the fence on the edge of the cliff, because one day there will be an ambulance below. So keep the company within that cliff and be the fence.
Thank you. That's wise advice, Sujain. I think we have had several questions, and I would request all those people. First, thank you for logging in. We had a tremendous response, and we have a whole lot of questions. And I would request economic law practice to actually look at those questions. And if you are able to reach out to all these questions and answer them, it'll be really a good gesture from you. And I think thank you very much, Mr. Vajpai, for being with us and sparing your time. And my special thanks to Sohail and Sujain from Economic Law Practices, and whoever is listening to us and viewing us, please reach out to the Economic Law Practices for more details and for any clarifications you may seek. They are extremely competent, well-known legal firm who can help us in these difficult times. So please feel free to reach out to Sohail and Sujain. And thank you very much, Economic Law Practices, once again, for collaborating with the Association of Independent Directors. And we look forward to continuing this collaboration with you and how we can reach out to our members. And thanks once again.